Hi, everyone. Welcome to our last session of the day, defending nursing home eviction cases. We are very fortunate to have with us today Eric Carlson from Justice and Aging. And this is being recorded and we will hold questions until the end, but you can type them into the Q&A box on Zoom at any time. And I am going to introduce Jocelyn, who will then introduce our speaker for today. Jocelyn Armand is the Advocacy Director for the Health and Income Maintenance Unit at Legal Services of Greater Miami. So welcome to Jocelyn and Eric. And Jocelyn, I'll pass it over to you.
Thank you, Christy. Good afternoon, everyone. It is my pleasure to introduce our esteemed speaker this afternoon, Eric Carlson. Eric is a directing attorney with Justice and Aging, where he currently leads a project to assist consumer advocacy on Medicaid managed long-term services and supports in Florida and New Jersey. Eric has broad experience in many forms of long-term services and supports, including home and community-based services, nursing facility care, and assisted living facilities. He counsels attorneys from across the country and co-counsels litigation on consumers' behalf. He also serves as president of the National Assisted Living Consumer Alliance and is the author of the legal treatise, Long-Term Care Advocacy. Thank you, Eric, for being here, and take it away.
Thanks, Jocelyn. So I do appreciate being here. We're going to talk about nursing facility eviction cases. As mentioned, I'm from Justice and Aging. We're a nonprofit, offices in Los Angeles, Oakland, and Washington, D.C. We focus on using the law to protect and benefit older Americans, particularly those with limited resources and those who historically have been unrepresented. We have a new diversity, equity, and inclusion program to focus on equity issues, both in the policy work that we do and also in how we run and operate our own organization. On the nursing facility topic, I want to start with a broad observation, which is a lot of nursing facilities operate in violation of the law. There's a wide scale mediocrity throughout the nursing facility world. There's a limited number of facilities that do a terrific job. There's a limited, but maybe more significant group of facilities that are really horrific. But the point I want to make is even the typical facilities, ones that may be considered okay generally, in actuality are probably out of compliance with the law in a variety of ways. And beyond just being out of compliance with the law, they're not doing a good job regardless of what the law is. For example, the regulations require care that is resident-centered, right? Focus on the individual, on the consumer. But oftentimes you don't see that. The better nursing facilities talk about a culture change in the nursing facility world, but to the extent the culture has changed, it's still in an unfortunately small number of facilities. So we all need to push back. The residents and their families, legal services, ombudsman programs, the surveyors, whomever, to change the understanding of what a typical nursing facility is. With that as a topic, I'll put in a quick plug for a book that Justice and Aging does called 25 Common Nursing Home Problems and How to Resolve Them. It focuses on this reality, consistent non-compliance, and lays out the law in a way that we hope is particularly useful to residents and to advocates. For each of these 25 problems, the guide lays out the misrepresentation, the lie, the falsehood that consumers are likely to hear, and it explains the relevant law, and along with discussion of advocacy strategies that residents and family members and professionals can use. And it's available for free on our website. So the law itself, the transfer, discharge, eviction discussion is based on the federal law that governs nursing facility operations in general. This federal law was enacted way back in '87, signed by Ronald Reagan as president, and it's been effective since October of 1990. It applies to each and every facility across the country that's certified to accept Medicare or Medicaid. And On the ground, that means basically every facility. There's a tiny fraction of facilities that aren't certified for either, but those are the facilities with a super high-end clientele, right? Residents with so much money that they don't care about Medicare and Medicaid, and neither does the facility. So there aren't that many of those facilities around, and particularly when you're in a legal services practice, your clients almost certainly are not in such facilities. So the short of it is the federal law almost certainly applies, and it applies regardless of the resident's payment source. So even though I just focused on certification for Medicare and Medicaid, that's on the facility side. If the facility is certified, they have to follow the law for each and every resident, regardless of how that resident pays. Resident may be paying through Medicare, through Medicaid, paying out of pocket, through third-party insurance, whatever the mechanism is, the federal laws could apply in a federally certified facility. And in reference to the law, I've listed the citations here, the statutory citations, and then the regulatory citation as well. The statutory citations are split between Medicare and Medicaid. So section 1395I-3 covers Medicare certification, and then 1396R within the US code covers Medicaid certification, but those two statutes are virtually identical. In general, the certification standards are identical. And so we can speak more generally about the nursing home, the federal nursing facility law without distinguishing between Medicare and Medicaid. And as a practical matter, most facilities are certified for both in any case. Under the federal law, there are only 6 allowable reasons for transfer discharge, and I've listed them here. The first 2 relate to the resident's care needs. Number 1, the resident needs more than nursing facility care. Number 2, so the resident supposedly no longer needs nursing facility care. 3 and 4 relate to endangerment of others in the facility. 5, the resident has refused to pay. And then 6, the facility is going out of business. Those are the only 6. If the facility wants to force somebody out, the facility has to be able to prove one of those 6. The facility's first obligation is to provide notice to the resident, to the resident's representative, and also for the last several years now, 2017 essentially, the facility's also been required to share a copy of that notice with the local long-term care ombudsman program. So the ombudsman program may be able to counsel people and advise them when they're subject to eviction. The notice has to be in writing in language that the resident and representative will understand, which brings us to the content of the notice. What does it actually have to list? The reason for the transfer discharge, which should be one of those 6 that we mentioned, along with enough facts so that there's an explanation of what the facility is alleging. For example, if the facility is claiming that the facility can't meet the resident's needs, there needs to be some listing of facts as to why that is. What are the care needs that the facility can't meet? The date of the proposed transfer discharge, or eviction rather, the location to where the resident's to be moved, the resident's right to appeal, which we'll discuss, and also the contact information for the local ombudsman program. Name, address, telephone number. And the same thing is true if this is a resident that would receive service from disability rights, the protection and advocacy organization within the state. The notice has to list the contact information for the protection and advocacy disability rights organization as well. The timing of the notice is generally 30 days in advance, although there are some exceptions. For example, if the resident has resided in the facility for less than 30 days. And in those situations of exception, the facility is allowed to give notice that is practicable, which may be less than 30 days. There's no guidance out there what practicable means. If you're looking for some detail on that, I think the best reference would be the provision within the regulation that says that there's no eviction while the appeal is pending. And that suggests, for example, that the notice can't just be, say, 24 hours from now or 48 hours from now, something like that. For this whole process to be meaningful, the resident has to be able to get the notice, request an appeal, and have the appeal held, or heard rather. And so that's what, if for some reason you ran into a situation where the facility gave just a few days, that's the argument that I would make to the facility and then also to the licensing agency. The regulations also require that there be documentation of the transfer discharge under certain circumstances. Basically, if the transfer discharge has something to do with the condition of the resident, as opposed to a payment situation. For example, or rather that there has to be documentation by a physician if the transfer discharge is based on something that is related to the resident's condition. That has to be by the resident's physician if this transfer discharge is based on what kind of care the resident needs, more than a nursing facility, for example, or less than a nursing facility. And that makes sense, because if you think about it, those two items of transfer discharge supposedly are for the resident's own interest. The facility is essentially saying, it's not, we don't care, right? There's no problem with you staying here. It's from our point of view, from our selfish point of view, it's just that if you stay here, we won't be able to meet your needs, or in the other direction, you don't need nursing facility care anymore. So in those cases, the documentation has to be done by the resident's physician. Or if the transfer discharge is based on endangerment, right, which is problems posed to others, other residents or other staff members in the facility, in that case, the documentation can be made by any physician. And then in the 2016 revisions, there are additional documentations requirements that are specifically set up to deal with situations when the facility claims that the resident's needs cannot be met in the facility. Okay. This is probably the most commonly alleged reason for eviction from a nursing facility, but historically, facilities have played relatively fast and loose with this, just broadly saying we can't meet your needs, right? But without really specifying exactly what those needs are, just these broad allegations, which are in some cases just a relatively flimsy cover for the facility's desire to force the person out. So to dig into those situations and force the facility to come up with more specifics, the regulations now require documentation of three things in those circumstances. First, the need or needs that supposedly can't be met, right? What is it that this resident needs that this facility can't do? Second, the efforts by the facility to meet those needs, right? The facility would say, in essence, well, we tried, right? This was the problem, but in good faith, we tried to address those needs by doing whatever it might be. And then thirdly, what is it about the proposed action by the facility that would meet the resident's needs? The transfer discharge notice would presumably propose to send the resident somewhere else. We can't meet your needs, so we're sending you to some additional facility, some different facility, facility number 2. The documentation requirement would demand that the facility show why it is that facility number 2 could meet the needs that facility number 1 allegedly can't meet. I want to point out, in talking about notice here, it's important to keep notice requirements separate, specifically in relationship to Medicare and Medicaid as well. So you may have notifications related to coverage from Medicare or Medicaid where the program is saying, we're not going to pay for this anymore. But that's not equivalent to an eviction notice, a transfer discharge notice. And so in those situations, if the facility wants to evict, there should be two separate notices. One would be the notice from the program, from the benefits program, either Medicare or Medicaid, saying we're not going to cover this anymore. And then independently, there would be a notice issued by the facility, presumably for non-payment, saying you haven't paid, and for what it's worth, the regulations require that there only be non-payment after the resident has been given a reasonable opportunity to pay after notice that describes what is owed. So that would be the sequence in these circumstances. It would be two separate notices reflecting the fact that one notice has to do with the public benefits program, and the second notice is from the facility if the facility is trying to force the resident out. As we'll mention, there's a tremendous amount of eviction-related problems in the circumstances when Medicare reimbursement ends. Just discuss it now to describe the scenario. The core of this is that facilities like Medicare reimbursement. It's the highest paying form of reimbursement. Unfortunately, from the facility's point of view, it's always short term. It's basically never more than 100 days under fee for service. It might be longer under Medicare managed care, a bit longer, for example. But in general, we can talk about being a capped at 100 days. And as a practical matter, it almost never gets to 100 days. The standard coverage for Medicare Part A coverage of nursing facility care tends to be more about a month, 26, 27, 28 days in that range, because Medicare coverage requires that there be a particularly intensive level of service following a hospitalization. And so, don't want to belabor this, but that's the core idea. It's a high payment rate, pays a high per diem, but for a limited period of time, oftentimes just a few weeks. So what do facilities do if they're really focused on money? Some of them will have as a business plan cycling through these Medicare eligible residents. You bring in a resident from the hospital for Medicare covered care for a month, let's say, and then once their Medicare coverage ends, you want them out. So you can replace them with another Medicare reimbursed resident. And what you don't want, again, from a cold-blooded financial point of view, is to bring in a resident under Medicare and then have them stay under Medicaid for potentially a long-term stay of months or years. So you will see some facilities that really do improperly evict residents as a business practice. Not all, I want to be clear about that, and these are generalizations. They don't apply to every facility, but they apply to a good many. What's the point of all this? The point is that it's important in those circumstances the residents understand what their rights are, understand that they don't have to leave at that point. There's a lot of chatter oftentimes about nursing facilities, about the resident being in a Medicare certified bed, or the facility saying we're a rehab facility, we're not a long-term facility, we're not a custodial facility. It's described in a variety of ways, but the message to the resident is once your Medicare ends, you gotta go on your way. And that is not true. There's ways of appealing a Medicare cessation of coverage, but even just assuming for the sake of argument that Medicare is over, the resident could stay under a different form of reimbursement, pay it out of pocket, or Medicaid, for example. And in any case, even if he or she didn't pay, the facility would be obligated to wait until there was non-payment after the facility had given a notice before the facility could move to evict the person. So what does that have to do with this slide? This slide shows the surveyor's guidelines is relevant to this discussion pertaining to the involuntary transfer discharge regulations. Just so folks know that these surveyor's guidelines are found in Appendix PP, that's the letter P twice, to the CMS State Operations Manual. It's a lengthy document. The guidelines, 600 pages, 700, multiple hundreds of pages with commentary on the applications of the regulations. And in this case, it just points out that a resident doesn't have to leave when Medicare ends. The operative language here is resident initiated. You always have to give a notice when the transfer discharge is initiated by the facility. If the resident just says, I want to go, thanks a lot, I appreciate the care they've gotten here, but I don't need to stay anymore and I'm leaving. If it truly is resident initiated, then the facility doesn't have to give a notice. But if the facility in any way is suggesting you should go now, time to go, you must go, any variations on that, it's facility initiated and the facility has to give a transfer discharge notice. And then the surveyor's guideline here says, just because you're leaving following rehabilitation, which is generally Medicare funded, does not mean it's resident initiated. You have the right to stay under a different form of payment. So the facility also has to provide some preparation. There's another regulatory requirement that the facility faces. The language in the first bullet point comes from the transfer discharge regulation itself. And then beyond that, just as is relevant to all residents, whether or not they're subject to transfer discharge, there should be a discharge plan. There needs to be a care plan in the facility for the resident. And unless the resident has opted out, that care plan should include whatever planning is necessary for transfer discharge. I mentioned appeal hearings. The resident has a right to appeal. This is in front of a hearing officer. It varies a little bit from state to state, and so I'm not in Florida, and so I can't speak to exactly how it's set up in Florida. But I can say these are administrative hearings. They, from the federal regulatory side, are subject to the same regulations that govern Medicaid fair hearings for legal services attorneys. So the principles are the same. You're not subject to formal rules of evidence the way that you would be in state court or federal court, but you do have a right to introduce evidence and cross-examine witnesses and make your arguments. Make a point here about the psychology of these. It's really important for the advocate and the attorney or the non-attorney, because you don't have to be a lawyer in order to represent folks in front of these, unless there's I can't speak to state rules as to the practice of law, but in general, it's something paralegals or other non-lawyers can do. It feels sometimes, absent really strong advocacy, as if things are stacked against the resident. If for no other reason, then there might be a lot of people prepared to testify against the resident, particularly in these situations where the resident has supposedly misbehaved in some way. That, let's say the facility is arguing that they can't meet the resident's needs, and they've lined up nurse aides and dietary aides and nurses and the administrator and the custodial staff, who knows whom, all prepared to say, yes, the resident was disruptive, called out, push me, push the staff member. I was trying to help the resident and maybe he shoved me aside, that sort of a thing. So, and it can feel a little bit overwhelming what the resident advocate has to do in these situations is to turn the table a little bit. Don't let the resident be a punching bag in these situations based on the principle that the resident is in a nursing facility for a reason. And oftentimes, the reason is related to Alzheimer's or some other dementia. And so to the extent that the facility and the facility staff are harping on non-compliance or bad behavior or whatever it is, the response should be, maybe in a more polite way, so what, right? It's in turn instead on what the facility needs to do. The facility needs to assess the resident. The facility needs to figure out, and these are all regulatory requirements, the facility needs to figure out what the problems are. The facility needs to care plan. The facility has to provide person-centered care. The facility has to provide adequate assistance. And so when there's a problem, the facility's first response should not be, oh, we've got to move this person out. The response instead should be, let's convene a care plan meeting. Let's bring in the physician and the nurse and the family member and figure out what we can do. So that's the kind of attitude the resident representative has to bring to this oftentimes, just to push back against the narrative that somehow the resident deserves eviction for behaviors that the facility claims are inappropriate. So with that, I want to turn a bit and look to some common fact patterns and then talk about defenses, affirmative defenses first, and then also ways of addressing the core of the facility's allegation. The facility's affirmative, not the facilities, but the residents' affirmative defenses in these cases, I suppose it's self-explanatory. The short of it is, these are situations where the facility failed to follow the proper procedure. And so all those requirements that I talked about 10 minutes ago about notice, for example, and whatnot, if the facility failed to comply with those, the argument is that they should lose. And there's arguments for and against that. I think from the facility side argument would be no harm, no foul on these notice arguments, right? They'd say, well, maybe we made a mistake, but didn't matter, right? Because here's we're in an appeal hearing. And so obviously the resident figured it out. And particularly if you've got legal representation, there's no problem here. Whatever violation occurred was trivial and shouldn't make an impact in determining the results on the merits. The argument against that from the resident side is that we can't run a system like that. You can't have a situation where the facility wins either way, because just assume the facility had a business practice of doing things inappropriately, right? They always gave bad notice. Maybe they didn't give notice at all, or they failed to list appeal rights, or they didn't list the facility to where the resident would be sent, whatever it is. And in that case, the facility would have one of these heads I win, tails you lose sort of situations, because if the resident then didn't appeal because the resident didn't get adequate information, the facility would win because it never would even be challenged. And then in those rare instances when the when the resident would appeal, the facility would turn around and say, oh, doesn't matter. There's no problem here because the resident came through anyway. And that's the argument to the hearing officer as to why that shouldn't be allowed, that to establish proper compliance by facilities, the standard has to be the standard has to be kept across the board. And so these are some of these requirements related to notice. And again, they're the same notice requirements that I mentioned a couple minutes ago. So if the facility didn't list a date of transfer discharge, didn't give the 30 days that's required, didn't give practical notice, didn't list the appeal rights, didn't list the ombudsman program or the protection and advocacy organization, those would all be reasons to argue that the transfer discharge shouldn't go forward. And I'll make one other point in regards to those. I have found that these kind of arguments have some appeal to hearing officers. Put yourself in the shoes of a hearing officer. And you've got these arguments related to these affirmative defenses, which are pretty simple, right? They're just notices. Was the notice adequate or not? And if you're going to rule on that basis, it's relatively straightforward. If you don't do that as a hearing officer, then you've got to figure out what the resident's care needs are and whether the resident is appropriate for the nursing facility. It's a much more complicated thing to sort out. So I have certainly seen a fair share of decisions that avoid the more complicated, and I think appropriately so for the reasons I just described. I do think there's from just a workload issue. There's some attractiveness probably to a hearing officer on basing a ruling on these threshold issues of notice rather than having to delve into all the testimony that the hearing officer might hear about care needs of the resident and the capacity of the facility. And so going on, also some potential affirmative defenses related to notice. As I mentioned, the notice requirements obligate the facility to list a locus of proposed transfer discharge. So there could be a violation by not listing the location or listing a location that is inadequate. You'll see a fair number of suggestions that the resident be transferred to the house of a son or daughter, for example. You see sometimes listed a local single room occupancy hotel. You'll occasionally see a homeless shelter. So all of those locations, for what I think are obvious reasons, are inadequate locations for transfer discharge. Another affirmative defense relates to those documentation requirements that I mentioned earlier. So I said that you needed the physician's documentation when the resident supposedly needs a different level of care, either higher or lower. Failure to have that documentation is a reason to vote for the resident, and also failure to have any physician documentation when the transfer discharge is supposedly based on the endangerment to others' safety or health. And also, just keep in mind as well, don't want to forget the regulatory requirement that the facility have documentation of 3 things when the facility supposedly can't meet the resident's needs. You remember those, the need that can't be met, our efforts to meet the need, and the ability of this second facility to meet those needs. So failure to list those, failure to show those would be an affirmative defense as well. So that's dealing with the affirmative defenses. Now let's go to the facility's main arguments and addressing those. First of all, the justifications that are based on the needs of the resident. The needs are the behavior of the resident. So we're not talking about non-payment here. We're talking about everything else. If you're representing the resident, what you want to do is to get the information from the resident's file. This should include, for example, the nurse's notes, the assessment document. This is the minimum data set, or the MDS, which just as it says, it's an assessment, and it assesses the resident's condition and needs in reference to a variety of different factors. It really is extensive. And then related to the assessment, there should be a care plan. We should reflect, first of all, cooperation between the resident's representative, and the facility and the physician on coming up with a care plan to begin with, and then should list what the facility will do in reference to issues identified by the assessment, and also the other issues identified by the resident's representative, the physician, or anybody else. As for the social service notes, and also oftentimes the medication administration record. It's going to vary. These days, records are much more likely to be electronic. It may be easier. Maybe you can. It's not as laborious to specify things, and their requests can be made for just for broadly the information that's available. But I mentioned these as documents that are specifically relevant to issues about the resident's condition and also the facility's ability or inability to address some of those situations. And then you'll also want some testimony from the resident, if he or she is in a position to testify, and that the ability to do so or not is going to generally be tied to the level of dementia that the resident may have. A family member, a physician, particularly if you happen to have a physician who is leaning towards the resident, or to, able to see things from a resident's point of view, or from a therapist as well. Just mention a logistical problem here. In the real world, unfortunately, the healthcare providers in general are more likely to line up with the facility. I wish it weren't so. You can imagine a world in which it weren't so, but that's probably the case more often than not. It's worth it to check with those people. They don't work with the facility. You can speak with them with no sense that you're talking to a represented party inappropriately, but you just understand that they may tend to line up with a provider just for reasons as you can probably understand, but which are unfortunate. And then in the hearing itself, you obviously, in the testimony, you want to bring out the reality of the resident's condition. I think there's a lot of this is just to show that what the facility is alleging is not really as cataclysmic as the facility suggests, particularly these endangerment situations. And again, not across the board. There may be some issues, some situations where the facility legitimately can't meet the resident's need, or whether the resident legitimately is endangering health or safety of others. But I'll say that in the real world, that's a tiny, tiny sliver of those situations that are out there. What I generally say is that if the regs are followed, the resident should almost always win. And why is that? First of all, I don't know any residents who are desperately trying to stay in a nursing facility that can't meet the resident's needs. If the resident really needs to be in a hospital, the resident's going to go to a hospital. If the resident really needs to be in a psychiatric facility, let's say, then the resident's going to do that. So there's just not this big pool of residents who are trying to stay in a place that can't meet their needs, and that's not the profile of the resident that we're dealing with here. In most of these cases that I've seen, what you've got, putting aside the non-payment cases here for a second, you've got a resident who's probably got dementia, at a level that is might be challenging, and or you've got a resident with a personality that is also challenging, and or a family member who tends to get in arguments with people, or maybe you're almost always in these situations, also have a resident that's being reimbursed through Medicaid and is a less desirable resident from the cold-blooded actuarial perspective of a nursing facility. That's what you're dealing with. You're not dealing with residents who desperately need a ventilator but refuse to go. You've got these other situations. A Medicaid eligible person who's not the easiest person for whatever reason, but is absolutely appropriately placed in a nursing facility. Absolutely. There's no one who's legitimately going to say who could get them placed in somewhere else. They're not going to be admitted to a hospital. They're not going to be admitted to a psychiatric facility. And you can oftentimes tell this from the transfer discharge notice, because the facility will propose to send this person to another nursing facility. So the argument is, look to the facility number one. If facility number two can take care of this person, and look, they're licensed just like you, they're certified just like you. If they can supposedly deal with this person, meet this person's needs, prevent him or her from endangering others, why can't you do it? And that's something, returning to this slide here, that you can come up with and demonstrate in cross-examination. You don't have to go wild on this. Not all of us are, I include myself in this, are killer trial attorneys. So it doesn't have to be some elaborate cross-examination, but it can pull out just these two basic points. The yes and no questions, right? You didn't do the care plan, did you? Well, you didn't bring the person back. You didn't have these conversations. You didn't do this. You didn't do this. You didn't do this. Right? That's sort of a cross-examination that establishes that the facility fell short, and then also a similar line of questioning related to just what I mentioned a minute or two ago. Facility number two. Facility number two, it's licensed the same as you, right? It's certified the same as you. The staffing is based, it's the same category of facility, and so they can meet the residents' needs. The facility number one should be able to do so as well. Some suggestions related to some of the payment issues. The records here could be different, of course. At that point, you're not worried about the care plan, for example, but you look at the admission agreement, see what it says, and also, this is not rocket science, but just look at the records of the payments that have been made. In a private pay context, you want to look at the charges that are authorized by the admission agreement. You have, in some cases, situations where the admission agreement just talks about a per diem rate or a monthly rate, but the bill will include all sorts of essentially a la carte charges for various items or services. So those can be contested on those basis. They're inappropriate if they're not specified in the admission agreement. Also, I mentioned this earlier, the regulations require that there'll be reasonable, appropriate notice prior to alleging non-payment. So if the facility didn't give adequate notice, didn't notify the resident and the representative what was owed, the resident has a defense there as well. There's also a couple of potential defenses that we should discuss that are relevant to Medicaid payment. First of all, the regulations require the facility to wait for processing of necessary paperwork. The way that non-payment is defined in the federal regulations, it's defined as non-payment after this necessary paperwork has been done. So if you're in a situation where, for example, a Medicaid application is pending, there should not be a transfer discharge for non-payment. I think the way to think about it is this. There is not payment at that point, right? The facility may be owed a few weeks or a month depending, and I guess if they took a small claims court, they'd have a claim in that venue because the money is owed. It's just that to prevent unnecessary transfer discharges, the federal regulations specifically say that facilities can't force the resident out until the Medicaid agency has had the opportunity to make a ruling. And in some cases, I've seen also that extends to an appeal of an initial determination. So you understand the basic principle is the facility has to wait for the Medicaid program to make a decision on whether it's going to pay or not. And then one additional strategy that I want to mention here, you get a fair amount of non-payment situations for Medicaid eligible people related to snafus around the initial month of coverage. Let's assume that the resident seeks eligibility in January and makes an application and thinks everything's fine, I'll get approved, and then it takes a couple of months, and then in March, let's say, the Medicaid program rules and says, in fact, the resident was not eligible in January and February because there's some piece of property in another state, some insurance policy, some kind of asset that people had forgotten about that the Medicaid program says puts the resident over the asset limit. And then that gets fixed and the application is approved, but you have the lingering problem of non-coverage in January and February and maybe March, and then the facility's asking for payment of $15,000, $20,000, depending on what region you're in, and the resident has no ability to pay that, none whatsoever, because let's assume a single person here. Their available resources are under $2,000. Their income each month, let's assume it's around $1,000. It's going completely to the nursing facility and I have no ability to pay that back. This brings us to this strategy. It is possible, it should be possible, to take that $1,000 each month going forward and designate it to the old bill rather than the current bill. Think about it as a deductible, as it is. It's $1,000 that's available each month to pay for healthcare. Maybe the current month's bill, that's the common way to use it, but also for other healthcare expenses that may be appropriate. So as always, it's good to use that share of cost, that patient pay amount, that deductible for healthcare that may not be covered under Medicaid, and also in this particular scenario, to use it for quote unquote old bills. So in the fact pattern I set up a minute or two ago, the resident could take that $1,000 each month and put it towards the old bill. Let's just say that, make it easy, let's just say that $10,000 was owed because of that problem, the January, February problem that we talked about. The resident could take the $1,000 each month, designate it towards the old bill, right? Then Medicaid would pay the entirety of the current month's bill. And then after 10 months, you would have paid back the old bill, paid off the old bill. So I recommend that as a strategy in situations like that, because as I've observed, it's a relatively frequent problem. Let's talk briefly about the returning after hospitalization situation or hospital dumping, depending on how you want to think about it. There is a right to return to the nursing facility. There's a bed hold. It depends upon state law. I can't speak to that. And then on top of the state law, there's a federal law, applies across the country, that guarantees the right to return to the next available bed, regardless of the length of hospitalization. If, I should emphasize this, if the resident's coming back to the facility under Medicaid reimbursement or Medicare reimbursement. And the bigger problem here, of course, is under Medicaid, because if they're coming back under Medicare, the facility probably welcome them with the red carpet and streamers and whatnot. But coming back under Medicaid, they have the right. And that makes sense because the bed hold, Florida, it's 7 days, 10 days. In most states, it's something, you're talking about something between 7 and 14 days generally. And again, I apologize for not being able to give you the specifics here. And for that limited amount of time, it may make sense for a Medicaid program or for an individual to pay for an empty bed in a nursing facility. But beyond that, it doesn't really make financial sense. Why pay for an empty bed for a month or 2 months or something like that? Just gets really expensive. It's not a good use of money. But this is where the federal law comes in. You've got a situation where a resident's been hospitalized, let's say for a month, wants to go back to the original place. The original place has a vacancy. Why not require the original place to take that person back? And that's what the federal law requires. If the resident's able to go back to the exact same room, that's preferred. If the exact same room is available, then the resident has a right to return to that exact same room. But if the exact same room isn't available, the resident, at least at a minimum, has a right to return to the next vacancy in the nursing facility. So if the resident has if the facility has an immediate vacancy, great, right now. But if the facility doesn't have a vacancy on that, when the resident's ready to come back out of the hospital, then the resident can wait. What about the next day, the next day, the next day? It's the next available room. And it's important for residents to keep that in mind, that the facility can't just avoid that in one day. It's a continuing obligation. And certainly the vast number of facilities are going to have the vast number of facilities are going to have a vacancy immediately. But even those that are supposedly full up are going to almost certainly have one in the very near future. But you do have situations where facilities push back against this. And from the facility's point of view, again, from a cold-blooded point of view of some facilities, this is an opportunity to evict people with, from their perspective, the facility's perspective, relatively little muss and fuss, right? Instead of forcing them out, that's a hard thing to evict somebody, to force them to leave. But if they're already out and you essentially just lock the door behind them, it can be, from the facility's point of view, easier, but inappropriate. So you do see these situations where the resident is ready to come back and the facility says, no, we're not going to take you. And they'll claim that they can't meet the resident's needs anymore, or whatever it is. And if you're an advocate in that position, you've got to really move quickly. I understand the unfairness of it. The facility is taking advantage of the situation. It's inappropriate, really distasteful, but there we are. And as a legal services attorney or an ombudsman, you've got to make something happen as quick as possible. Because if it doesn't happen really quickly, the resident's going to lose interest and just give up and say, I can't get back, and rationalize. Say, well, they don't want me, I guess I don't want them. Someplace else is probably fine. What can I do? Again, the clock is ticking, and there's a couple of options. But again, it requires some real advocacy, some real hustling, and some high quality advocacy or litigation. The non-litigation route is make a complaint to the local licensing agency and make it urgent, emphasize the fact that the facility is trying to get away with something here, they're taking advantage of the situation to essentially conduct an illegal eviction. That's what's going on here. And particularly if you have a relationship with a local licensing office, in some sense that they might do the right thing, that might be the route to go. Because if a licensing agency takes it seriously, they have the ability to immediately go to the facility and read them the riot act and do whatever they need to do to get the facility to take the resident back. The other possibility is filing a court action. you're seeking injunctive relief, immediate injunctive relief, a temporary restraining order to get the person into the facility. The underlying cause of action or causes of action could be, depending on the state that you're in, illegal eviction under the common law, violation of a consumer statute, unfair business practices, for example, and emotional distress, and also third-party breach of contract. The argument there being that there's a contract between the facility and the Medicaid agency that obligates the facility to comply with the law. The beneficiary of that, right, who's not a signatory to the contract, but a third-party beneficiary to that agreement is the resident. The resident's benefited by the facility's agreement to comply with the law. And so because of that, the resident should be able to file a breach of contract cause of action in these circumstances in order to get relief. So you seek a temporary restraining order, get in front of a local judge, trial court, and make the argument. The good news here is that the judge is likely going to understand the concept of a lockout, essentially. Right? It's obviously analogous to a similar action in a landlord-tenant situation. Right? The resident or the tenant in this case just is away from the residence, and the facility essentially changed the locks in a effort to avoid the transfer, discharge, eviction protections that the resident or the tenant, as the case may be, would ordinarily have. And if folks are interested in this, I've got some sample pleadings, and we'll have something like that on our website available. I'll tell you, I'll put those, I'll share those with the conference and have those put online, if attached to this session as well. I didn't think about that originally, but I'll add those documents, some template complaint and a template injunctive relief application to the materials available to attendees of this conference. And then to wrap up here, and then we'll take some questions, I'll just flag some of these fact patterns. These are common justifications, improper justifications, but common justifications for transfer discharge, for eviction in a nursing facility setting. The first one, disruptiveness. I've alluded to this a couple times. This is the person with dementia. It's the fact pattern I really mentioned a couple minutes ago. Somebody with dementia, just difficult, challenging from a nursing facility care perspective, but absolutely appropriate for a nursing facility level of care. This is a nursing facility resident. Again, maybe not the easiest one, but absolutely a nursing facility resident and deserves to stay in a facility where she, in this case, can get the care that's necessary. The second one here, based on Medicaid reimbursement, the facility may say, well, you're eligible for Medicaid. We just can't do what's necessary for you given the limitations of Medicaid. What's relevant here is a requirement in the nursing facility law that says that there shouldn't be any discrimination based on form of payment. And specifically, there shouldn't be any Medicaid discrimination. You should never have a situation where a facility says, oh, yeah, we could do that, but not for your reimbursement. It's inappropriate, just like any of us as the lawyers that say you can't provide bad care just because you don't like how much you're getting, bad representation just because you don't like what you're getting paid. You take the work, you got to do it correctly. And note here that nobody's forcing nursing facilities to be certified for Medicaid. They don't have to. It's a choice. They have chosen to take Medicaid reimbursement. And as part of that choice, the facility has signed an agreement with the feds and the state. It says, I will accept Medicaid reimbursement, and in return, I will provide care up to this standard of care set by these regulations. And so if the facility is going to do that, and if the facility is going to take the money, then the facility absolutely should not be turning around and telling the resident that they're not going to provide adequate care. There has to be some integrity here. And if the facility's taking the reimbursement, they've got to provide the services. Third one, you plateaued in your physical therapy. This allegation refers to a Medicare term that oftentimes, Medicare is oftentimes predicated in a nursing facility. Medicare Part A in a nursing facility is often predicated on the person needing skilled rehabilitation services, physical therapy, occupational therapy, speech therapy, and you hear frequently claims by a therapist or a nursing facility that Medicare is not going to pay anymore because the person has supposedly plateaued. That is not correct under Medicare law. That under the regulation and under a settlement that you can find on the website of CMS and the Center for Medicare Advocacy as Jimmo versus Sebelius, JIMMO, that is inappropriate, that physical therapy, any kind of rehabilitation should be provided when it's necessary, and it's not required that the person progress if the therapy is necessary to maintain the person's condition, for example, it is justified. So the 2 points made to be made in relation to this item are, number one, plateauing is an inappropriate reason to terminate Medicare reimbursement for nursing facility care. And then secondly, as we mentioned 20 minutes ago, that's separate from the eviction decision, right? There's a coverage decision, that's Medicare, it's got its own procedures, and then there's a separate procedure that talks about whether the resident has a right to stay in a nursing facility or not. And as we discussed, even assuming for the sake of argument that the Medicare has ended, person has a right to stay under a different reimbursement source and also has access to the eviction appeal processes as opposed to the Medicare appeal processes. And then the fourth bullet on this page, I think we also address this as well to a certain extent. This is Medicare related. Again, facility suggesting that the person's got to go once their therapy is ended. As I mentioned, that's not true. It's Medicare related only. A person can stay under a different form of reimbursement. And then wrapping up, the first point here is a level of care issue. And in general, I think the facilities never justified, never, I guess you never say never, right? But almost never justified in saying that it can provide an adequate level of care, except for those situations when a person needs a ventilator, and those are available in a limited number of facilities. But for situations like that, the facility just has to provide the requisite level of care. And if that means for some residents, it's one-on-one or the equivalent of one-on-one, well, so be it. That's just how it is. There are certainly other residents who don't require that level of attention, but some residents do. And you've got to count on that all shaking itself out at the end. But the facility doesn't have any right to draw a line in situations like that and claim supposedly that it can't provide that level of care. What it's saying instead is that it chooses not to, but that's not an adequate justification for eviction under the regulations. And then the final improper reasons we'll talk about here is a resident who is refusing care for some reason. It could be medication, it could be something else. As we all know, none of us have to take medication. A doctor can recommend medication for me, can order it for me, but I need to accept it. There has to be informed consent. And the same thing is true in a nursing facility. So non-compliant or refusing care is not a justification. If the situation falls into one of those other six, then that's one thing. If for some reason there's endangerment of others, let's say, I don't know exactly what that fact pattern would be, but if the facility can put it into those scenarios, then there can be a discussion. But the facility is not acting appropriately to the extent that it tries essentially to create additional justifications for transfer discharge. There's only 6, and one of them is not you've refused care or you're not listening to your physician. So with that, we will close. Again, I want to say it's really appreciate being here, speaking with you. By all accounts, it's been a terrific conference. And if we've got any questions, I'd be happy to answer them to the best of my ability.
Thank you for a strong finish to our day. I certainly learned a lot. I really appreciate you sharing all that information with us, as well as the supplemental materials. So I'll get that uploaded onto the FeedLoop platform. I appreciate you sharing those. People are being shy today, but we do have one question here. Does a resident have a right to request discovery from the facility for the fair hearing?
Yes, that you have the resident has a right to his or her records. It's a federal regulatory right. It's probably in state law as well. So it's I usually don't think of it as a discovery procedure per se. It's the same request you can make at any time. There's a regulation. It's one of the subsections of section 483.10. So in the federal regulations, Title 42 CFR 483.10, there's a lengthy list of resident rights. And one of those rights is access to records within a short period of time. And so you make the request under that, and not there. And there may well be, I can't speak to whether there's administrative subpoenas and whatnot, but even putting that aside, the simpler way to do it is just to request the information from the facility based on the rule that the resident has a right to access records relating to him or her. And as long as the resident authorizes it, then the representative should be able to get those records. As discussed, half an hour ago or so, we looked at some of the documents that a attorney or other representative might want from the resident's records, the MDS assessment, the care plan, and the other things that we talked about.
Okay, as a follow-up to that question, the person asked, what about video of an incident?
I haven't seen it before. I want to say yes, and I suppose that, whether that's a resident record. Certainly my answer is going to be yes. But I don't have any hands-on experience with dealing with that or getting an objection from the facility. So I don't have any response beyond that as to how it might play out.
Always worth a try, right? The worst they can do is say no.
Yeah, I mean, I want to be optimistic about that, right? Of course, right? It is a resident record. It documents what's happening. If it's relevant and the facility's sitting on it, absolutely.
Okay, well, that's it for questions. So thank you again for being here today. I really appreciate it, and thank you to everyone who attended. As a quick reminder, there is a short survey after each session, so we would appreciate it if you complete that for us. And the conference will begin at 12:30 tomorrow, so we hope to see you all tomorrow. Have a good evening.